All right, in this section, we're going to talk about accounting for the debts of the parties and how they should be divided as a part of your DIY divorce. The general rule to remember is don't assign a debt to one spouse when the other spouse's name is the one that's attached to the debt, or if it's a joint debt, because the legal principle involved here is your debt, if it's a joint debt, it's considered joint and several liability in the law. And so your divorce the court only has jurisdiction over the two of you. They don't have jurisdiction over any third-party creditor. And so I've been told this by folks who work for, various creditors, and they've said, people will say, but yes, that debt was assigned to my husband. And the creditor will simply say to them, well, gee, that's too bad because we've decided we're going to go after you. And they don't even have to go after the husband. That's the point of joint and several liability. And so you want to make sure that the only debt you're taking out of your divorce is debt that has your name alone on it. And that's just a really good principle to keep in mind. And if you absolutely have to keep the other person on it because of, credit reports and such like that they can't refinance that debt, then you want to make sure that you include in it some consequences. So I'll get into that in just a few minutes. What I want to talk to you about next, though, is how the court views your debt in a divorce, because we're looking at the general principle that everything is considered a marital debt. And so, that's not especially true. So when would the court consider it non-marital? And I just wanted to give you some examples from cases I've had in the past. But the general question to ask is, how was the debt acquired and who benefited from that debt? And generally, the courts will consider that both parties benefited from it. But I had one case where I represented husband and wife had some plastic surgery that she put on a credit card. And husband looked at me and said, I didn't get any benefit from that. And so we just said to her, no, we consider that your non-marital debt. And she agreed. So then I had another situation where I represented wife. And on that one, husband had a golf card. And if he took a trip or if he bought new golf clubs or anything like that, or the golf fees and stuff, it all went on that credit card. Well, he's the only one that received the benefit of that. His wife and kids had nothing to do with it. So we agreed that that debt would be considered his non-marital debt. So have that discussion. Also, I want you to be aware of there is a statute. It's Minnesota Statute 519.05 that talks about liability of a spouse on debt, on joint debt. And that is generally, if you have a credit card that has just your name on it, you're going to be the one solely responsible for that credit card, not the other party. And that's especially true if the two of you are no longer living together. The only thing under that, the liability you might have, is for a medical debt, like say the kids were sick and stuff like that, that would continue to be a joint debt. So you want to be looking at all of the debts of the parties and how you're going to be dividing it up. There's also a couple other cases where the courts do consider it non-marital debt that I just want to talk about. One is student loan debt. And generally, I've had the situation where a wife, in that case, she had gone to nursing school, but she said, hey, we lived on that, student loans while I was in nursing school. And so what we did is we went back to the school and we found out what the actual tuition was and the cost of the books. And that was considered her non-marital portion of the debt. And then the rest of it was considered marital debt for purposes of the division of that debt. And so keep that in mind on student loan debt, because a lot of us have student loans. Then I finally want to talk about bankruptcies, because that's a little stickier area. Generally, my rule of thumb on bankruptcies is if the two of you have joint debt together, consider doing a bankruptcy before filing your divorce, because, get it wiped out for the two of you. because you don't want the consequence that that there's joint debt and it's assigned to one party or the other, and now one of the parties goes and declares bankruptcy after the divorce, and all of that joint debt will now attach to the other spouse. And the courts are mixed in how they will handle that post-dissolution. Some courts will say, well, they discharge that, and so it's no longer their liability. But I do think it opens up for some questions on, was it a fair and equitable division of the property then, if a part of that was that this spouse, A, who declared bankruptcy, whether they now have discharged that responsibility, and whether that makes it fair and equitable. So I just want you to be aware of it and to be thinking about it and to have the discussion about it prior to doing your final divorce. So the other thing to do is marital debt does belong on the balance sheet, and it can affect the property settlement in some ways that I've already told you about, but there's some other things to think about. It can be grounds for reducing the amount of spousal support that you pay if you're an obligor, if you take on some of additional debt as a part of the property settlement. What I'm telling you is this is a good place to have a discussion with an experienced family law attorney, because it is not, property settlements are not that easy, especially once you start thinking about all of these various things that I'm saying is net values, marital versus non-marital, and all of the various distinctions between pre-tax and post-tax. So I just wanted to make you aware of it. So there we are. That's the end of this section, and good luck on dividing up your property.